Hi, my name is Lisa Beisteiner and my mission today is to give you a basic understanding of the term emergency arbitration. So imagine you conclude a contract with an arbitration clause, obviously, and halfway through performance of that contract, you find yourself in need of urgent interim relief. For instance, you build a house and your contractor just refuses to continue the works, or your counterparty tells you they will draw down unwarranted a bank guarantee. In the, so to say, old world of international arbitration, until about some 10 years ago, you just had two options. One, you could go to arbitration. As you know, file a statement of claim, nominate your arbitrator, the other side nominates the arbitrator, the tribunal is constituted, the file is transferred. That takes some time, a couple of months probably, and then you may address your request for urgent interim relief to your tribunal, just that any relief that they could grant would come much too late. So option two, you could go to the state courts. The good old state courts, they're always there for you, but remember, you contracted out of state court jurisdiction and you did so for a reason. So that was not a very pleasant situation to be in. And arbitration people thought very hard about what could be done to solve that problem. And it was about 10 years ago that the major arbitral institutions in Singapore, in London, in Paris, in Stockholm, they, one after the other, came up with a solution of that problem, the concept of, you guess it, emergency arbitration. And that concept is actually quite simple. If you urgently need interim relief, as in our example, you need your contractor to be ordered to continue that works, or you need that counterparty to your contract be prohibited from drawing down that bank guarantee, and that relief just can't wait for your tribunal to be constituted, you turn to an arbitral institution, which is a standing body, and the arbitral institution will then, as a matter of hours or like 2-3 days, nominate a neutral third party, the emergency arbitrator, and this neutral third party will grant an interim resolution of your dispute in a very fast manner. 2 weeks maybe is seen as a standard, under some rules 5 days. That is very fast. Of course, emergency arbitration, just as arbitration more generally, is a creature of contract, so you have to agree on it, and the specific rules of the process will depend on that party agreement. Practically, it will depend on the rules, the institutional rules that you opt for. What will the emergency arbitrator do? First, she needs to determine whether she has jurisdiction and whether the application is admissible, and then move to the heart of the matter, so to say, decide whether the application is justified, so decide whether she should grant that interim measure. And in that respect, it's not the test that is to be applied, is not expressly regulated, but one can argue that the same substantive standards do apply as for arbitral interim relief more generally. And importantly, when doing that, when granting that relief or refusing that relief, the emergency arbitrator will do all that in an extremely fast process. A couple of days, 2 weeks, that is very fast. So you can imagine that the procedural calendar will be dictated by the emergency arbitrator typically. There will be a hearing by video link typically, and so on. But at the same time, the emergency arbitrator is bound by the same minimal procedural standards as an ordinary arbitral tribunal. That means that she has to give both sides an opportunity to present their case, and she has to treat both sides fairly. And very often, as you can imagine, it will be difficult to fully reconcile that speed and due process. And what you get at the end of the day, the decision rendered by the emergency arbitrator, is binding upon the parties, but only for a limited period of time. So the applicant must initiate the main arbitration within a short period of time, and once constituted, the ordinary arbitral tribunal will have the authority to lift the measure or to amend the measure. And once constituted the arbitral tribunal, the emergency arbitrator loses her job, so her mandate ceases. So you note that emergency arbitration never finally decides the merits of a dispute. It gives a temporary solution pending the formation of the main arbitral tribunal, and the order, that solution, is easily removable. And the emergency arbitrator may never serve on the main arbitral tribunal. So you get high speed, but reduced finality, as we would say. And maybe after all you've heard, you ask yourself now, is emergency arbitration at all? Is that decision that you get at the end of the process an arbitral award at all, for the purposes of the New York Convention or for the purposes of a certain national arbitration law? And those are indeed good questions, and they're heavily debated. And in fact, the questions can only be answered for a specific jurisdiction against the concept of arbitration that this jurisdiction embraces. And let me say only so much. For Austrian law, which I do practice, and which is an ancestral model law jurisdiction, I personally don't think that emergency arbitration is arbitration proper, but even though decisions are not directly enforceable as arbitral awards and don't have the quality of arbitral awards, they are at least contractually binding, and of course they do have a substantial natural weight. The emergency arbitrator has a substantial natural authority, so that this tool, emergency arbitration, can serve its purpose.